Perfect. Thank you all for joining us today for our presentation on E-2 visa requirements and renewal considerations. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC in New York City. My colleague Kelly Legrand-Wiener was going to join us today. It will be me presenting. She is available for a consultation if you would like to speak with Kelly directly. So what we are going to cover today is what is probably our firm's most popular visa. It is actually the visa that our firm was founded on. Scott Legal PC is an E-2 company. Ian Scott, our founder, started it over a decade ago. So the fact that he has personally navigated the process really does inform the way that we work with our clients. So before we get started, I did want to cover a few housekeeping items. The first is that this webinar is part of a series. We try to do at least a couple webinars a week, and those do cover a range of U.S. immigration topics. So our firm does handle family immigration. We handle temporary visas like the E-2, like student visas, visitor visas, really the full spectrum of U.S. immigration law. So if you have any questions at all, please don't hesitate to reach out and schedule a consultation and speak with us. Again, our webinars do span the full spectrum of U.S. immigration law, and we record our webinars. We post them to our YouTube channel. So on our YouTube channel, you can see not only those full-length webinars, but also shorter videos that cover, again, a variety of immigration topics. After this presentation, you will receive an email from us with a link to our YouTube channel, as well as a comprehensive E-2 visa guide, where we take really our best practices that we've learned over the years and share them with you for free. We do hope that's helpful. If you have a question during this presentation, please do send it in using either the Q&A function or the chat function on Zoom. I'll be monitoring those. I'll probably save questions for the end of the presentation, but don't let that stop you from sending them in at any time. I'll be monitoring those. All right, without further ado, let's go ahead and dive in. So the E-2 visa is one of the best options for someone who wants to come to the U.S. to develop and direct their own business, whether that is by them starting a business themselves, a startup, purchasing a franchise or starting a franchise, or buying an existing business. All of those are viable pathways. So let's talk about some of the requirements for an E-2 visa. The first is that you need to be a national of an E-2 treaty country. Now, fortunately, there are dozens of E-2 treaty countries. If you're curious, you can Google E-2 treaty countries. You'll see a list that's published by the U.S. Department of State. These countries are all over the world. Canada, Mexico, South America, Europe, Asia, Australia, all over the place. Japan, Korea. So really there are dozens of E-2 treaty countries. Some of the countries that are not E-2 treaty countries are China, Brazil, India. So there are certainly a few very notable and high population countries that are not E-2 treaty countries. For those countries, there is an option for nationals of those countries to become citizens of an E-2 treaty country through, for example, investment. That was a more popular option several years ago. Now it is still an option, but you need to have actually lived in the country that you have citizenship in. For example, Grenada, Turkey is another popular option. You actually need to have lived in that country for 3 years before you apply for the E-2 visa. So it is certainly an additional hurdle. That being said, the door is still open if you are able and willing to do that. When I say you need to be a national of a treaty country, what that means is that you need to hold a passport from a treaty country. You do not need to have been born there. So as an example, a very common example, let's say you were born in India and you moved to Canada and you naturalized in Canada, and now you are a citizen of Canada. You would be eligible to apply for an E-2 visa because you have a passport from Canada. Another example that I like to use is, let's say you were born in Uruguay, but your parents are Italian and you have Italian citizenship through your parents. Uruguay is not an E-2 treaty country. Italy is an E-2 treaty country. So even though you've never set foot in Italy, if you have a passport from Italy, you do meet that E2 nationality requirement because you have that Italian passport. Now, the next requirement you see is that the E2 company must be at least 50% owned by nationals of the treaty country. So, in general, what will happen if someone is applying for an E2 visa, one of the first things they'll do is set up a company in the United States. And that can be a corporation, it can be a limited liability company, an LLC. Really, either are fine. Either option, any of the options are fine as long as it is a legitimate business entity in the United States. And the E2 investor applicant will own personally and directly at least 50% of the company. And that is a really critical threshold. You do need to make sure that you own at least 50% of the E2 company in the US and that you maintain that ownership percentage. So if you're starting a company and you think you're going to sell equity in the company, then the E2 visa might not be the best option because you always do need to own at least 50%. If you're going to sell equity and you'll sell no more than 50% and you'll continue to own 50%, that's fine. It doesn't matter who owns the other percentage of the company as long as you maintain at least 50% ownership in the E2 company. Now, that also means that you can have two E2 investors based on a single company if both of them own 50% of the company. And this can create some interesting and quite helpful scenarios. So let's say you are a national of Canada, you own 50% of the E2 company, and you have a friend who is a national of Germany who owns the other 50% of the company. That company can have dual E2 nationality. It can have Canadian and German citizenship or nationality in the example I gave. And the reason that's relevant is that a company can have E2 employees from either of those E2 countries. So if the E2 company, in the example I used, has both Canadian and German nationality, then employees can apply from Germany or Canada to come to the US and work for the E2 company as managers, executives, or specialized employees. If the company only has one nationality, then they would be able to have employees from that one nationality. Let's say it's a Canadian company, they could have Canadian E2 employees. Now, the employees would have to meet the requirements for as E2 employees, as executive managers or specialized employees, but they would meet that nationality requirement if they hold a passport from the treaty country. Next requirement is that, actually related to the requirement I just mentioned, is that the E2 investor needs to come to the US to develop and direct the E2 company. So they cannot be a passive owner of the company. They actually need to be active managers, actively growing the business, marketing it, networking, selling products. So that is an important requirement. Next, the E2 investor needs to make a substantial investment in the E2 company. This is one, we'll talk more about this, but this is one of the most common questions. How much do I need to invest in the E2 company? The answer is that it depends on the type of company you're starting. There is no set dollar amount. If you're starting a manufacturing company, the amount might be much larger than if you're starting a law firm, for example. That requires very little overhead. So you need to invest enough to make the business operational, ready to start operations the moment you get the visa. Those funds that you invest into the company need to be at risk. That means that they actually need to have been spent. You cannot simply transfer your personal funds into a business bank account and leave them there and apply based on that. You will very likely be denied. The government wants to see that you've actually transferred your personal funds to the E2 company, and then the E2 company has spent those funds on marketing, on computers, on an office lease, on paying contractors or employees. So you do actually need to put the funds at risk by spending them. Source of funds. This is oftentimes much of the application, the E2 application, is proving where the funds that were invested in the E2 company came from. Now, fortunately, you can use basically any legal source of funds. As long as you acquired the funds legally and they are your personal funds, there are very few sources of funds that are not going to be permissible. So you can use a gift from a family member or a friend as long as you can document where they got the funds. You can use a personal loan. So if you get a loan from a bank that's secured by your personal assets, you can use that. You can use earned income from work. You can sell an apartment and use those funds, and inheritance, insurance proceeds. We've seen all of these. They are all fine. Examples of what would not work are, for example, a loan that is secured by the E-2 company. You cannot use a loan that's secured by the E-2 company. You can use a personal loan. Another example, cryptocurrency can be permitted if you have solid documentation of where the funds came from and that they were invested on a cryptocurrency exchange and then withdrawn from that exchange and then invested in the E-2 company. As long as you have documentation showing the path, that can be fine. However, if you are using cryptocurrency proceeds that are not documented, that may very well be a problem. So you do need to document both the source and the path of the funds from the source to the E-2 company. This is particularly true if you're applying from within the U.S. through USCIS. USCIS does not have a page limit on its applications, and they will scrutinize the source of funds and the path of funds. If you're applying at a consulate, typically consulates will have page limits. So in those cases, you oftentimes won't even be able to provide comprehensive documentation showing the source and movement of funds. You'll need to explain where the funds came from and provide a sample of documentation showing that your explanation of where the funds came from is true, but you won't be able to map out every single transaction, where the funds started, where all the accounts they traveled through before they got to the E-2 company. USCIS will require that documentation. Next, the business must be real and operating. So I said before that the funds need to be spent on everything needed for the business to be operational. So the question that may be asked at the consulate and that you need to be able to answer in the affirmative is, if you are granted the visa, you will be prepared to immediately come to the U.S. and start operations. That there's nothing else the business needs to start operations. If you can't answer that question in the affirmative, if there is something you're missing, something the business needs to start operations, if you need an office space, if you need inventory, if you need a license or a permit, you may be denied because the government wants to see you've lined everything up for the business to be operational as soon as you arrive. So purchase everything you need for the business to be operational, line it all up, and then you are ready to meet this real and operating requirement. Related to this is certain business types. We'll talk about these a bit more later. Certain business types the government is skeptical as to whether they are actually an operational business. So, for example, real estate investment companies or equity investment companies, stock investment companies can be scrutinized because oftentimes the government will say, well, this is not an operational company. This is a company that buys property, holds it, waits for it to appreciate, and then sells it. And that is not an operating company. That's a passive investment. And it doesn't clearly require the employment of workers. So we'll talk more about this later, but you do need to structure those applications to make it clear this is an operating company. This is a company that will require workers. You would probably need a business plan to show that if the business isn't already operating. Next, hire U.S. workers. I say this is the make or break requirement for an E-2 application. And what I mean by that is, if you fail to convince the government that your business will employ U.S. workers, you are almost certainly going to be denied. On the other hand, if you convince the government officer that your business will employ U.S. workers or already does employ U.S. workers, then you may be able to overcome other weaknesses in the application. So let's say you have a low investment amount, but you already have U.S. employees and you're already selling a product or a service, then you may very well be able to overcome that low investment amount because you have U.S. workers. this is a really key requirement. You do not need U.S. workers before you apply, but if you don't have them, you need a very good business plan explaining exactly when you will hire, uh, what the demand for your products and services are, such that you will need employees, etc. So a comprehensive business plan is key if you don't already have employees before you apply. And finally, the E-2 visa is a temporary visa. It's a non-immigrant visa, meaning it is not a green card. It does not lead to permanent residency. So it is important that your application make clear that you have the intent to return to your home country once your E-2 status ends. This is usually just shown in a letter that you sign and include in the application. It's usually not a high burden, but it is important to establish. So let's look at options and timing for getting an E-2 visa. So first, as I mentioned, you would start the business in the US. You would decide what state you want to create the company in, whether it's a corporation, an LLC, or another form. You'd start that company. You would apply for an employer identification number with the IRS, the US tax agency. Once you have the employer identification number, you would open a commercial bank account in the company's name. You would transfer your personal funds into that business bank account, and you would spend those funds to set up the business. Spend it on everything, again, the business needs to become operational. At that point, you would typically be able to apply for an E-2 visa. If you don't have employees, again, you would need a business plan, or if you're able to get the business operational from abroad, maybe you can hire a manager in the US who starts operations, serves a couple clients, shows that there's demand for the service. That's wonderful if you can do that. If not, you can apply based on the business plan and explain that once you get to the US, the business will be operational. So how long is the E-2 visa valid for? This depends entirely on almost entirely on your country of nationality, the country you have a passport from. There is what's called reciprocity, where the U.S. will limit the time of an E-2 visa depending on whether the foreign country also limits the validity period of a U.S. applicant. There are other factors that go into it. The takeaway is you can Google reciprocity E-2 or Department of State reciprocity, and you can actually see for every country how long the visa is issued for. In general, the maximum amount of time that an E-2 visa will be issued for is 5 years. The minimum amount of time, I think the shortest is 3 months. Fortunately, most of our clients are applying in countries with 5-year validity, including Canada, for example, many of the countries in Europe. So 5 years is common. The other reason, though, that an E-2 visa validity can be limited is if the officer decides to do that. So an officer always has discretion to decide that they want to limit the period of the visa. So even if you're from a country with a 5-year reciprocity, the officer can say, for example, this seems to me to be a risky business. I want to see if it's successful in the first couple of years, and then I want you to come back. And at that point, I'll decide whether to renew the visa. So they might limit it to 2 years, 3 years, whatever that is. They do have that discretion. We don't see that happening often, but it does happen. When you enter the U.S., regardless of how long your visa is valid for, when you enter the U.S., you are generally given 2 years of E-2 status. And what that is the period of time that you can stay in the U.S. in E-2 status. So if you get a visa for 3 months, an E-2 visa for 3 months, you can seek admission into the U.S. as long as that visa is valid. So let's say you ask for entry on the last day of that 3-month validity period. The visa is valid, but it's the last day of validity. You should be able to enter the U.S. And when you do enter the U.S., you are generally given 2 years of E-2 status. So the visa is for entering the U.S., seeking entry. Status is how long you can stay, and they are completely independent. This is why it's important every time you enter the U.S. to check your I-94 online. The I-94 is a document that controls how long you can stay and what your status is. So again, one of the most common questions we get is, how much do I need to invest? Fortunately, but also unfortunately, there is no set dollar amount. This is unfortunate because there is uncertainty. You're never sure if you meet the investment requirement. You can never point to a law and say, hey, it says I need to invest this much and I've done that, therefore I meet that requirement. You can't do that. But the benefit is that this is largely dependent on your argument. So, and it does open the door to lower investment amounts. And in fact, our firm takes pride in the fact that we do help people who generally don't have a lot of money to spend. Um, and what I mean by that is under $100,000 to spend on the business. So $100,000 is generally, as a very general benchmark. If you invest under $100,000, many consulates in the world would see that as a relatively low investment amount. That does not mean a denial. What it means is that the application will be scrutinized, will be looked at a little more closely so that the officer is convinced that this actually will be a viable business. We have many clients who apply with less than $100,000 to invest. Our firm was started with, I believe it was about $25,000. That is a very low investment amount. We generally do recommend that our clients invest more than that amount. But the takeaway is that it can be done, particularly if the business is already operational, already employing workers, already generating demand and selling products. So there is no set dollar amount. What the regulations do say is you need to invest a substantial amount. And that, as I mentioned before, depends on the type of business. So what you do need to show in your application is that you've spent everything that's needed for the business to be operational. This is why a law firm or a consulting company can apply with a lower investment amount because they might need just a couple computers, an office lease, very low overhead. Whereas if your business is manufacturing batteries for electric vehicles, you're going to need to show you've invested a lot of money to get that business operational. That might be in the millions of dollars. Fortunately, there is something called the proportionality test, which basically says if a business requires more money to become operational, the government will accept a lower percentage of that investment amount being satisfied. So to take a concrete example, a consulting company that requires $100,000 to start. The government's going to want to see that 100% of that $100,000 has been spent because, again, $100,000 is relatively low. If your business requires $10 million to be started, the government might say, you know what, we'll accept $8 million. We'll accept 80% of that amount being invested. You don't need to actually invest 100% of that. That's what the proportionality test says. I'm not going to spend a lot of time on the proportionality test because, as you can probably tell, very few applicants will actually be investing in the millions and millions of dollars. These are usually larger companies that are doing this. For the vast majority of our clients, they are investing $100,000, $200,000, $300,000, and in those cases, you need to invest 100% of the funds. Now, let's talk about buying a business versus starting a business. So, if you're buying a business, what is a substantial investment? It is basically the fair market value of that business. So, if you're buying a business that's on the open market and you're paying the fair market value, you likely are meeting this requirement and don't have anything to worry about. If you're buying a business from a family member, that's where things could be complicated because the government will ask, well, are you actually paying fair market value? So it may be important in those cases to get a third party, an accountant, to do a valuation of the company to show that you're actually paying the fair market value. Franchises can be an excellent option for an E-2 visa because franchises have a track record. They're recognizable to the consular officer. Also, franchises will oftentimes, the franchisor will list out the required expenses. So there will be marketing expenses, computer expenses, software expenses. And so you can show the officer, these are the expenses that the franchise says I need to spend, and I've spent those funds. So it's a very clear way to show that you've actually invested the funds needed for the business to be operational. And finally, there are common good and bad E-2 visa expenditures. So good expenditures are really anything that's needed for the business to be operational. I'd say probably some of the best expenditures are paying employees, paying contractors, U.S. contractors. Payments on an office lease can be an excellent expenditure. Payments on equipment or inventory, those are excellent expenditures. Weak expenditures are, for example, travel expenses. If you're paying for flights from Canada to the US to set up the business, that is a weak expense. We typically would not even include it. Hotel costs staying in the US. Educational expenses. So if you're starting a law firm, you would not include your law degree, your law tuition, as part of your investment. The exception to this is if you need a certain certification for your business type. So let's say you're starting a restaurant in Wyoming, and Wyoming has the Department of Health in Wyoming requires you to take a course. That might be a valid expenditure, but otherwise, investment in education for yourself, not going to be a good investment. The last thing I'll say is I mentioned before that the substantial investment amount depends on the type of business, but even if your business does not require much money, let's say you're starting a law firm and you can start your law firm for $25,000. Even then, we would recommend that you try to find ways to boost your investment amount because, again, the consulate generally likes to see at least $100,000 being spent. So the closer you can get to that amount, the better. So some common ways that people will do this is if they spend everything that the business needs to be operational, they might spend more on marketing, which can benefit their company. I wouldn't recommend spending money just to spend money. I think there are usually opportunities to spend money to benefit the company. Marketing fees can be a good way to do that. Paying for an office lease for several months in advance can be a good way to increase the investment amount. And finding someone in the US to do marketing, to create a website for you, to help you with administrative issues. That can be a wonderful way to boost expenses, boost your investment amount, while still showing that you're going to employ a US worker, which can really benefit the application. Do I have to hire US employees? You do, but not before you apply. So it is critical that you convince the government that your business will employ U.S. workers over a 5-year time frame. And this is usually what we recommend is the E-2 company needs to employ at least 3 full-time equivalent U.S. workers within 5 years of starting operations. Better if you can start that hiring early in that 5-year period. But really what matters is that by the time you apply to renew the visa, you can show that you have those at least 3 employees. If you hire them in the month before you apply to renew your visa, that's not going to look good. So try to start hiring as early as you can. Once you hit those 3 full-time equivalent employees, you don't need to actually increase that. Once you hit 3, you're generally fine. So if you don't have those employees before you apply, again, a business plan is going to be critical. We prepare business plans for our clients. They are 30 to 40 pages long, very detailed. They show exactly how the company is going to sell its products and services, how that's going to require employees, when the employees are going to be hired, their job title, their job duties, their salary. Really, these are detailed business plans, and that is what you need if you don't have employees before you apply. If you do have employees before you apply, then it's really great to include W-2 forms, payroll records to show the government that you really are employing U.S. workers. Now, if you are buying a business in the U.S., one of the most important things to look at is how long the business has been operational and if it has employees. Because if you are buying a business in the U.S. and that business has been around for 10 years and it has only employed the owner, only the owner has been working there, they haven't had any employees, that's going to be a really hard sell when you show up at the consulate and you say, I've just bought this business, it's been operational 10 years, it's generated tons of money, and it's had no employees. They're going to say to you, well, what are you going to do to employ employees, and why should I believe you're going to do that when the previous owner didn't do that over 10 years. So try to set yourself up for success by finding a company that already has 3 employees. At least 3 employees. That way you can show, when you show up at your interview, I'm buying a company that already has 3 full-time employees, and I'm going to keep doing what the previous owner did, keep employing those 3 workers, and help those employees earn a living and generate a living for myself and my family. That's a much easier application to sell. Business plan considerations. So what does a business plan include? Probably the most important part of a business plan is the executive summary that really gives the key highlights of the business plan. And that's because consular officers don't spend a lot of time with applications. They are not likely to read your entire business plan. They're likely to read at most the first couple pages. So make those first couple pages really key, very strong, highlighting the important points. That's what the executive summary is for. Next, it is good to include a market analysis and research showing how you are going to market your products and services, who the competitors are, similar to the marketing plan. The personnel plan is critical. That is a plan that shows over the next 5 years. We do look at the 5-year time frame just because that's the maximum period of time that an E-2 visa can be issued for. Showing over the next 5 years when you are going to hire each employee, what they're going to be paid, talking about what their job titles and job duties will be. Next, the comprehensive financial plan, and that is closely related to the personnel plan because the financial plan is going to support the personnel plan. If the financial plan shows revenue of $20,000 a year, it's going to be hard to explain how 5 employees are justified. Whereas if the financial plan shows strong demand, $150,000 of profits, many products or services being sold, then you can start to explain, okay, we will need 5 employees to generate this. The financial plan will also have a balance sheet, income statement, and cash flow statement. Those are common components of the financial projections. So a few considerations. Should you apply at USCIS or a consulate? So USCIS is an option only if you're inside the US. And what you would be applying for specifically is a change of status if you don't already have E-2 status. So let's say you're in the US on an F1 visa, you're Canadian, and let's say you went to accounting school, you got a degree as an accountant, and you want to start an accounting firm on an E-2 visa. Your options, since you're in the US on an F1 visa, your options are either to apply for a change of status from F1 to E-2 status through USCIS, or to apply at a consulate for an E-2 visa. If you're Canadian, that would be at Toronto. In most cases, our recommendation would be to apply at a consulate. And the reason is that USCIS does not issue visas. What they issue is status. So if you are that F1 student and you apply through USCIS, what you are going to get if you're approved is 2 years of E-2 status in the US. The moment you leave the US, you abandon that status. And if you want that status again, you're going to have to go to the consulate in Toronto, or if you're from another country, the consulate in your home country, apply for the E-2 visa, and then you'll be able to come back into the US and leave and come back in E-2 status. But if you don't have that visa, then you abandon your E-2 status the moment you leave the US. So for that reason, consulates, it's a much more convenient option. USCIS is also more expensive, especially if you're doing premium processing. You can apply for an expedited decision. They will give you a decision within 15 business days, but that does cost about $3,000 to expedite that application. Consulates are taking much longer than the 15 business days, but right now it really is in generally the 3 to 6 month time frame. Some consulates are much faster, some are slower. Toronto right now is taking around 3 to 4 months between the date you apply and the date of your interview. So that's not particularly long. It's also far cheaper to apply at a consulate. and again, you get a visa. Now, so who would apply through USCIS? Well, if you're already in the US and you let's say that we have our F1 student accountant, and she says, I want to start business as soon as I can. Then what we would say is, well, you're already in the U.S. Why don't you file a change of status application with the USCIS at the same time that you apply for a visa at the consulate? So you have two parallel applications. USCIS will get you a decision in 15 business days if you expedite it. So once you have that decision, you can start working at your accounting company. You would stay in the U.S. and only leave once the consulate has called you in for an interview 3 or 4 months down the road. And then you'd get your visa and come back in and be able to continue working for your company. So that's an example where you'd apply through USCIS. Also, if you are from a country with a very short validity period, so let's say you're from one of these countries with a 3-month validity period, once you enter the U.S. on the visa, 3 months is going to fly by. So many people in those situations will extend their status through USCIS. They won't go back, to their home country every 3 months. That would be very onerous. So they'll just extend their status through USCIS. So that's another example where USCIS makes sense. Another consideration, I already mentioned this, but the source and trail of funds, very important to prove where you got your funds from, especially if you're applying through USCIS. So if you do have the option, let's say that you are to continue with our F1 student accountant example. Let's say that she got her funds through a very complex, numerous gifts from cousins and uncles and parents, and they all got the funds from different sources, selling apartments and working over decades. Very complicated source of funds. She could apply through USCIS, but she might say, you know what, that is just going to be way too difficult to prove the source of funds. Let's go to the consulate where they have a page limit, where they're less likely to scrutinize the source of funds. Loans secured by company assets are not allowed. Again, a loan is allowed as a source of funds if it is secured by your personal assets, if it's a personal loan. Gifts are fine, but keep in mind that you do need to show where the person who gave the gift got the funds. So that a gift doesn't get you around proving the source of funds. Considerations for a small investment amount. I touched on this already. There are ways to strengthen an application if you have a small investment amount. When I say small investment amount, I mean under $100,000. Best way to do this is to employ U.S. workers. That's the best way to strengthen an application with a small investment amount. Another way to strengthen the application is to get letters from prospective clients talking about how they look forward to working with you, engaging the company once you have your E-2 visa and the company begins operations. You can also get a letter from a CPA, Certified Public Accountant, where the CPA explains that in their experience, you've invested enough to make your business type operational. So if you're starting, say you're starting a tattoo parlor, and you've invested $40,000, you might get a letter from a CPA saying, you know what, I've seen these types of businesses get started before. They do generally require a low investment amount, 20 to 30,000. So 40,000 is sufficient in my experience. That letter could help. You can get E-2 visas for 2 investors as long as each investor owns 50% exactly of the E-2 company. This next bullet, substantive changes to the business after filing. This can get quite complicated, but basically what happens if you file an E-2 application, say, to run a restaurant in the US, and you decide that you want to start creating websites and selling websites. You're a great graphic designer and you are good at programming and creating websites. If you did not in your application say that you want to both run a restaurant and create websites, that's going to be a problem because that's a substantive change to the business. The government thinks you're running a restaurant. Creating websites is not that. So in that case, what we would recommend is, first of all, think about what you might do in the US and include that in the application. So if you think you might create websites in addition to running a restaurant, make your application so that it says that this business is going to do both. It's going to run a restaurant and create websites. If you didn't do that beforehand, you may need to apply for an amendment, either at the consulate or through USCIS. And we have done this before. It can be straightforward depending on the circumstances, but really, I think the important takeaway here is don't make a substantive change to the business before you talk with an immigration lawyer. Stick to the plan you've communicated to the government because you don't want to get in trouble for working without authorization. When you have an E-2 visa, your work authorization is limited to the E-2 company. So if your E-2 company was only running a restaurant and you start creating websites, you are arguably, you're violating your work authorization, and that can create problems. Higher risk cases, real estate investment companies, equity trading, these are risky because the government oftentimes thinks that they don't require U.S. workers, and the government will sometimes question whether they are in fact operational or passive. And I mentioned this before, but if, for example, your company purchases land or purchases real estate and holds on to it hoping it'll appreciate and then sells it, it's not clear why you need employees. So if you have one of these companies, it's really important to show, especially important to show that you already have employees or will require them. Similarly, family business purchases. This is risky, again, because you need to convince the government that you paid the fair market value for the business. So if you're buying from an uncle or a parent, the government might ask whether you got a preferential price and therefore did not pay a substantial amount for the business. So you do, if you can get a third-party valuation, that can be a great idea in those cases. Okay. So common reasons for E-2 denials: low investment amount, we've talked about that quite a bit. Nature of the business, we've also talked about that. Real estate investment, equity trading. The filing location and venue. So I mentioned this in terms of USCIS requiring solid source of funds documentation. That's an example how where you apply does make a difference. Similarly, certain consulates tend to see larger businesses. So particularly in Japan or Korea, they tend to see very large E-2 companies that have many, many, many employees. So when they have an applicant who has a startup where they invested $60,000, it can be harder to be approved in those cases. So in those, we do see those approvals, but it can be more challenging. So if you have the option to apply in different locations, that factors into the strategy there. Next, if you have a business in your home country that performs the same service or produces the same product and you haven't employed workers, that can be a hurdle. So let's say that you have a business in the UK and let's say it's a consulting company and you want to start a consulting company in the US, but your UK company has existed for 10 years and you've never had an employee, or you've had one employee. You're going to need to be ready to explain to the officer what you're going to do differently in the US such that you need more employees and you're going to meet that 3-employee requirement. So, again, it's about setting yourself up for success. If you can bolster your hiring abroad, that could help. But also, I think most importantly is having a clear explanation about what you're going to do differently in the US such that you'll require employees. Next, issues with the officer. So if you're applying at a consulate, consular officers basically have complete discretion as to whether to approve or deny. They don't even really need a reason to deny. We find that most officers are well trained, are fair, are good at their jobs, and the decision is what we would expect. However, there are certain officers that just are either not well trained or just do not like approving applications. And it's unfortunate. It's rare for that to happen, but it does happen. And if that does happen, your option is to apply again. There is, in general, no prohibition on applying a second time or a third time. And you can take the feedback from the officer, incorporate it into the application, strengthen the application, and apply again. Fortunately, consulates tend to try to assign your application to a different officer if you're applying a second time so that you really do get a fair shot. And finally, we We do see people will sometimes come to us after they've been denied, and we'll look at the application and see that they actually didn't qualify. They might not own 50% of the business. They might have only transferred funds into the bank account and not spent it. So you do need to meet the E-2 requirements at the time of filing. So what does it take to renew an E-2 visa? The most important thing is to hire U.S. workers. You do need, our general recommendation, have at least 3 to 5 full-time equivalent U.S. workers before you apply to renew the visa. And in the application, you do want to show that the business has been successful. You'll include tax returns for the company showing its revenue, its profits, its compensation paid to employees. Include profit and loss statement, business plan, payroll information showing compensation paid to employees, W-2 forms. If the company's not doing well, then in the time before you apply to renew, it can be worthwhile to hire employees and really try to get some clients on board, maybe some letters of intent for companies that or clients that want to sign with you in the future. Really doing whatever you can to strengthen the application before you apply to renew. And the company does still need to meet the initial E-2 requirements. So ownership needs to remain at least 50% by the E-2 investor. The business should not have changed from what was communicated to the government. So do keep that in mind. And finally, a few developments and adjudication trends and considerations. E-2 visas do have very high approval rates. The government's official statistics show about an 80 to 90% approval rate. Our approval rate is in the very high 90% realm. Past performance is not a guarantee of future outcomes, but that is our track record. We do see that the consulates want to see that the majority of the invested funds have been spent in the U.S. In the past, we wouldn't see issues if, for example, someone were running a business and buying inventory from China and selling it in the US, and most of their investment was that inventory in China. Now we would say, look at the total amount you're investing of your personal funds. Let's say it's 100,000. Spend at least 50,000 inside the US. Do not spend 80,000 on inventory in China. The government has been scrutinizing that. Government might want higher investment amounts, so if you can increase your investment amount before you apply, that can be time well spent. Especially important under this administration to hire U.S. workers. You don't need to hire U.S. citizens. Really, anyone who has work authorization in the U.S. does count as a U.S. worker. However, U.S. citizens and permanent residents do carry more weight than, say, someone on a work visa, an H-1B, a TN, etc. Focus on employees rather than contractors. Contractors do count, 1099 contractors within the U.S., but U.S. employees, W-2 employees, carry the most weight. So try to hire employees rather than depending on contractors. There is an exception to this if the industry relies on contractors. So for example, certain types of businesses will just use contractors. It's not normal to use employees. If your business is in one of those industries, it can be fine to use contractors, but try to have more than 5 contractors. Try to show that you engage them over a long period of time and there's not high turnover, because the government likes seeing that you're creating ongoing and regular opportunities and income for workers, even if they're contractors. Next, administrative processing. This is an unfortunate trend where consulates will basically do a security screening, and it can take a while. It can take a few days or it can take a few months. It is a black box. They will not tell you what they're looking at, and it seems to be random. So it's just a reality of the current situation. Fortunately, it is rare for this to happen. It's not the majority of applications. It's just something to be aware of. We did see more USCIS filings during COVID when it was difficult to cross borders and travel. Now I think we are back to seeing mostly consular applications. And finally, waits were longer during the pandemic at consulates. They have come back down to their normal times, fortunately, which is again between 3 and 6 months from the date of applying to the interview date, and then you'll usually get your visa within about a week of the interview date. All right, I know some questions have come in, so let's look at those. Is it normal to use an escrow account to pay, let's say, business expenses? And that's a great question. The answer is escrow agreements are perfectly fine to use. You can use escrow. That is one of the few exceptions to the requirement that you need to put the funds at risk. So if you are buying a business, or as this question is asking, going into a franchise, you can put those funds into an escrow account so that they are released the moment the visa is approved. And that is the one condition that's allowed, is approval of the visa. If you have any other conditions, then you're going to have a problem. But as long as the escrowed funds are released upon visa approval, immediately upon visa approval, that is fine. Does change of status hurt the case later when the interview comes? No. It is fine to apply through USCIS for a change of status, and then to go to the consulate for your visa interview. Change of status does not impact the case. Now, the flip side of that is it doesn't necessarily strengthen your consular case. So you cannot say, hey, I was approved for a change of status, therefore you should approve my visa. The consulate will not honor that. They are going to do their own review of the application. Franchise or personal business, good for the case. Either is good for the case. Franchises are great, or startup is fine. We have clients doing both regularly. Can we go ahead with two businesses completely different from each other for an E-2 visa? The answer is it depends. If you're talking a single business entity that is selling completely different things, that is fine as long as that was communicated in the E-2 application. What is going to be a problem, though, is if you've created two different businesses, two LLCs, two corporations, whatever, and they're doing two different things because your E-2 visa is for a specific entity. All right, it is tied to the specific business entity, a specific corporation, a specific LLC, and you can only work for that business or LLC. One of the few ways to get around this is if you have your E-2 visa with company A and you are an owner of company B, a passive owner, but your services are being contracted out to company B. So company B basically pays company A for your services, does not pay you, but pays company A. You can have a management services agreement where you are providing services to the other company you own. But there are a number of things to be aware of if you're doing that. You do not want to violate the law. It is worth scheduling a consultation if you have questions about that. I'm going to buy a franchise for $70,000. Can I leave the rest of the money as cash in the business account? That's a great question. You can have working capital. So as long as you spend all of the funds that are needed for the business to be operational and you've spent a substantial amount, you can have additional funds as working capital in the business bank account. What it is that you cannot depend only on working capital. So if you put $100,000 into a business bank account and don't spend anything, you'll be denied. If you spend $70,000 and have $30,000 as working capital, that's probably going to be fine depending on the business type. Can the officer say there's no risk if I use escrow account? Escrow account is the one example where you can show that your funds are at risk without actually spending the funds, and this is clear in government guidance. So it is clear that that's the government's position. So UK citizens thinking of an E-2, we have 2 children who are US citizens. Can we employ our children? Will this count towards the 3 at renewal? So the answer is it depends. You can employ your children at the E-2 company, assuming they have work authorization. Here they're US citizens, so they can work. They would not count toward the E-2 employment requirement. So let's say you have 5 children and you employ them, you have not satisfied that requirement to employ 3 to 5 US workers. Because immediate family doesn't count, and family in general doesn't count. So, fine to employ them, but you need to make sure you have 3 other US workers at the company. It's very common for a spouse, by the way, to work for an E-2 company because E-2 spouses get work authorization once they come into the US. And it's fine for them to work for the E-2 company. They just don't count as one of the 3 to 5 employees. How long is it taking in London from submitting to the interview date? That's a great question. London is running slowly right now. It is taking, I'd say, at least 6 months from the date of applying to the interview. Could take a little shorter, could take a little longer, but I think 6 months is probably the time frame to have in mind. All right, that answers the questions that came in. Thank you all for taking the time to join me today. Do keep an eye out for our email. Read that guide we send you. We'll also send the PowerPoint that we had on the screen for you. Check out our YouTube channel and reach out for a consultation if we can be helpful. Thank you so much for taking the time. We hope to see you again soon. Thank you.